All right, guys, this is an important one. It is 9:15 p.m. On Monday, September 8th, and I'm going to go through an order today and a concurrence and a dissent. And we're going to talk about how today the United States Supreme Court carved out an exception to the Equal Protection Clause in the 14th Amendment to the United States Constitution, so that that Equal Protection Clause no longer applies to the 60 million Hispanic and Latino people who live in the United States of America. And they did it in one paragraph, and they did it without any explanation whatsoever. This was an emergency motion filed by the Trump administration while the court is out of session. And so this decision came up on the court's shadow docket, meaning that there was no full briefing on this issue. There was no oral argument on this issue. There was no lengthy deliberation among the justices on this question. Because there was no oral argument, there was no questioning from the justices of the attorneys presenting this case. This decision is absolutely atrocious. Earlier today, the court, also on the shadow docket, overturned an 80-year precedent in a case where they said, yes, Donald Trump can violate our precedent, and now he can fire people from the Federal Trade Commission. They did that on the shadow docket. I was shocked by that because the case that they overturned had been precedent in good standing for 80 or 90 years. Then they came out with this decision. And now the Equal Protection Clause of the 14th Amendment of the United States Constitution, which has been in place for 160 years, no longer applies to Hispanic or Latino people living in the United States. This came about when some plaintiffs filed a lawsuit against the Trump administration for the tactics that ICE was using in rounding up people in Los Angeles recently. ICE, by their own admission, the government, by its own admission, was racially profiling Hispanic and Latino people in the United States. They were looking for people who speak Spanish, who speak English with a Spanish accent, who have low-wage jobs, and who congregate at places like day laborers congregating at Home Depot, and low-wage jobs like day laborers, car washes, things like that. The government admitted that that's what they were doing. There is a long history of case law from the United States Supreme Court that says that racially profiling, when law enforcement racially profiles people, that is expressly illegal, and it violates those defendants' rights under the Equal Protection Clause of the 14th Amendment, rendering those activities also unconstitutional. And today the Supreme Court said, no, we're fine with that, despite the government's admission that that's what they were doing. And they did it on the shadow docket during their summer break with no full briefing and no oral argument. This is absolutely horrific. When those plaintiffs sued the Trump administration in federal court in Los Angeles, the judge in that case initially issued a temporary restraining order against ICE being permitted to use those tactics. That decision came out a few weeks ago. The Trump administration filed an emergency petition with the Supreme Court, and that has been decided on the shadow docket today. And it was decided with one paragraph. Because the Trump administration was applying for a stay on that lower court's decision implementing an injunction, a temporary restraining order. Here's the paragraph. Here's the entire decision. The application for stay presented to Justice Kagan and by her referred to the court is granted. The July 11th, 2025 order entered by the United States District Court for the Central District of California, give the case number, is stayed pending disposition of the appeal in the United States Court of Appeals for the Ninth Circuit and disposition of a petition for a writ of certiorari, if such a writ is timely sought. Should that writ be denied, this stay shall terminate automatically. In the event that cert is granted, the stay shall terminate upon the sending down of the judgment of the Supreme Court, this court. Weirdly, it's a 6-3 decision. This is extremely weird and atypical. Justice Brett Kavanaugh wrote a 10-page long concurrence with that paragraph. He spent 10 pages concurring with that paragraph. And the way he frames his version of the circumstances here is, this is no big deal. This is no big deal at all. They just took constitutional rights away from 60 million Hispanic and Latino people in the United States, including citizens. The Immigration and Nationality Act authorizes immigration officers to interrogate any alien or person believed to be an alien as to his right to be or to remain in the United States. Immigration officers may briefly detain an individual for questioning if they have a reasonable suspicion based on specific, articulable facts that the person being questioned is an alien illegally in the United States. That already contradicts the first paragraph. The reasonable suspicion inquiry turns on the totality of the particular circumstances. Then Kavanaugh goes through a whole bunch of facts. Facts which are not in the court record. He's just saying these things. There hasn't been a trial and a decision where witnesses testified, evidence was introduced, creating a record on appeal. There is no record on appeal. Justice Kavanaugh just starts spouting off facts and doesn't cite them to anything. He's telegraphing to the Trump administration, when you appeal this case to us, we will take this case and we will decide it in your favor. He is telling the Trump administration that ahead of time. The government estimates there are 15 million people in the United States illegally. Many millions entered just in the last few years. Illegal immigration is especially pronounced in the Los Angeles area, among other locales in the United States. About 10% of the people in the Los Angeles region are illegally in the United States, meaning about 2 million illegal immigrants out of a population of 20 million. Doesn't cite any of those assertions to anything. He just says it as though they're true. Not surprisingly, given those extraordinary numbers, the U.S. immigration officers have prioritized immigration enforcement in the Los Angeles area. The government sometimes makes brief investigative stops to check the immigration status of those who gather in locations where people are hired for day jobs, who work or appear to work in jobs such as construction, landscaping, agriculture, or car washes that often do not require paperwork and are therefore attractive to illegal immigrants, and who do not speak much, if any, English. Again, no citations, just saying it. If the officers learn that the individual they stopped is a U.S. citizen or otherwise lawfully in the United States, they promptly let the individual go. That is nowhere true over any point in time over the last 8 months. ICE has detained dozens, if not hundreds, of U.S. citizens. ICE has deported U.S. citizens, including children. So what Justice Kavanaugh said there is a flat-out lie. He's just lying. If the individual is illegally in the United States, the officers may arrest the individual and initiate the process of removal. Immigration stops based on reasonable suspicion of illegal presence have been an important component of U.S. immigration enforcement for decades, across several presidential administrations. He's trying to paint this as normal. He's trying to normalize taking constitutional rights away, equal protection under the law, from 60 million Hispanic and Latino people in the United States, including 50 million citizens. It's disgusting. In this case, however, he goes through some, okay. In this case, however, the district court enjoined U.S. immigration officers from making investigative stops in the Los Angeles area when the stops are based on the following factors or combination of factors. 1, presence at particular locations such as bus stops, car washes, day laborer pickup sites, agricultural sites, and the like. 2, the type of work one does. 3, speaking Spanish or speaking English with an accent. And 4, apparent race or ethnicity, racial profiling. It is racial profiling. Racial profiling by law enforcement is explicitly illegal and unconstitutional under decisions from this court. And he's just, The government contends that the injunction will substantially hamper its efforts to enforce the immigration laws in the law enforcement area. The government has therefore asked this court to stay the district court's injunction. And then he goes through some other stuff. In my view, the government has made a sufficient showing to obtain a stay on appeal. Here we go. To begin with, given the significance of the issue to the government's immigration enforcement efforts, this court would likely grant cert if the Court of Appeals affirmed the district court's injunction, meaning this court will hear that case. That's the reason, that sentence is why he wrote this concurrence. He's laying out the argument that the government should make on appeal to the U.S. Supreme Court. He's giving them the argument to make, and he's telling them that they will accept the case beforehand. He is prejudging a case that is not before the court, and he has no factual basis whatsoever to do that, other than it's his favorite president who appointed him to the court. He goes through some more of that same bullshit, but I'm getting angry, so I'm going to move on to the dissent. A 21-page dissent written by Justice Sotomayor, who frames the facts a bit differently. In early June, the government launched immigration enforcement raids across Los Angeles and its surrounding counties. During the raids, teams of armed and masked agents pulled up to car washes, tow yards, farms, and parks and began seizing individuals on site, often before asking a single question. Racial profiling. Illegal. Unconstitutional. A federal district court found that these raids were part of a pattern of conduct by the government that likely violated the Fourth Amendment against reasonable search and seizure. Based on the evidence before it, the court held that the government was stopping individuals based solely on 4 factors: their apparent race or ethnicity, whether they spoke English whether they spoke Spanish or English with an accent, the type of location at which they were found, such as a car wash or a bus stop, and 4, the type of job they appeared to work. Concluding that stops based on these 4 factors alone, even when taken together, could not satisfy the Fourth Amendment's requirement for reasonable suspicion, the district court temporarily enjoined the government from continuing its pattern of unlawful mass arrests while it considered whether long-term relief was appropriate. Instead of allowing the district court to consider those troubling allegations in the normal course, have a trial, create a record for appeal, a majority of the Supreme Court decides to take the once extraordinary step of staying the district court's order. That decision is yet another grave misuse of our emergency or shadow docket. We should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work a low-wage job. Rather than stand idly by while our constitutional freedoms are lost, I dissent. And then there's more facts. In early June, the government launched Operation At-Large in Los Angeles, deploying roving patrols of armed and masked immigration officers to local car washes, Home Depots, tow yards, bus stops, farms, recycling centers, churches, and parks. Over the course of the next month, the government made nearly 2,800 immigration-related arrests and detained many more. For instance, on June 9th, immigration agents arrested at a tow yard in Montebello carrying handguns and military-style rifles. Jason Gavidia, a Latino U.S. citizen, was working on his car in the tow yard that day. A masked agent ordered him to stop right there and began asking him questions. Agents then asked Gavidia if he was an American at least 3 times, and 3 times Gavidia affirmed that he is. Unsatisfied, the agents asked Gavidia for the name of the hospital in which he was born. And when Gavidia could not immediately recall, the agents racked a rifle, took Gavidia's phone, pushed him up against a metal gate, put his hands behind his back, twisted his arm, cuffed him, and took him into custody. Agents released Gavidia only after he offered up his real ID. That ID was never returned to him. Less than 10 miles away in Whittier, immigration agents raided a car wash managed by U.S. citizen Jorge Viramontes. In the 9 days between June 9th and 19th, agents returned 4 times, each instance in the middle of the workday. On one occasion, an agent questioned Viramontes, asking if he was a citizen and requesting that he show his ID. Viramontes replied that he is a dual U.S. and Mexican citizen and supplied his California driver's license. The agent said that ID was insufficient, grabbed his arm, escorted him to a vehicle, drove him to a warehouse for further questioning. Agents detained Viramontes for 20 minutes while they made calls to verify his U.S. citizenship and examined his Mexican ID before eventually driving him back to work. Other Operation At-Large encounters have included even more force and even fewer questions. For example, agents pulled up in 4 unmarked cars to a bus stop in Pasadena. The doors opened and men in masks with guns started running after 3 Latino men who were having their morning coffee, waiting to be picked up for work. In Glendale, nearly a dozen masked agents with guns jumped out of cars at Home Depot and began chasing and tackling Latino day laborers without identifying themselves as ICE or police, without asking questions, and without saying anything else. In downtown Los Angeles, agents jumped out of a van, rushed up to a tamale vendor, surrounded him, and handled him violently without asking any questions. Masked agents with guns ran out of the vehicles and rushed towards workers at a car wash. 3 masked agents wearing bulletproof vests got out of a car with rifles at a Home Depot and tear-gassed the crowd. The operation has sparked panic and fear in Los Angeles. Some have likened the detentions to kidnappings. Those plaintiffs, among others, moved for a temporary restraining order. That restraining order was granted. And indeed, the government submitted no evidence suggesting that its seizures to date were based on anything other than those 4 unconstitutional challenges or factors. The court further found that a plethora of statements suggested approval or authorization of the government's pattern of relying solely on the 4 factors, and that there is a real immediate threat that the conduct complained of will continue. Thus, the court held that plaintiffs had standing given the high likelihood that it would happen again. They keep going back to the same locations and using the same tactics. The court then held that the seizures based solely on the 4 factors likely violated the 4th Amendment because officers cannot rely solely on generalizations that, if accepted, would cast suspicion on large segments of the law-abiding population. Yeah, the other 90% of Hispanic and Latinos who are U.S. citizens. It's incredible. And the court issued a restraining order. The government appealed to the Ninth Circuit. The Ninth Circuit noted that the government chose not to dispute that these detentive stops have been based solely on the 4 enumerated factors and did not challenge the district court's finding that those stops are part of a pattern of conduct that has apparent official approval. And they refused to lift the stay. So Trump goes to his buddies on the court. And they lifted the stay with a 1-paragraph order. 1 paragraph. Taking constitutional rights away from every single Hispanic and Latino person in the United States, including the roughly 50 million of them who are U.S. citizens, massive numbers of whom voted for Donald Trump. The government, and now the concurrence, meaning the concurrence by Justice Kavanaugh, has all but declared that all Latinos, U.S. citizens or not, who work low-wage jobs are fair game to be seized at any time, taken away from work, and held until they provide proof of their legal status to the agent's satisfaction. As the district court found and the government does not meaningfully contest, the present evidence reveals that the operation at large seizures of people occurred based solely upon the 4 enumerated factors, either alone or in combination. The government now asks this court to bless that conduct, at least temporarily, by issuing a stay. The government has not, however, demonstrated the necessary likelihood of success on the merit to warrant this court's extraordinary intervention. Well, I think Justice Kavanaugh took care of that in his concurrence. He gave the Trump administration the arguments to make on appeal to the Supreme Court and told the Trump administration that they would hear that case. And he gave them a roadmap for how to argue it. It's fucking amazing in the most horrific, horrible manner. The Fourth Amendment imposes limits on search and seizure powers, and the Fourth Amendment and the 14th Amendment both apply to undocumented immigrants if they're on U.S. soil. The entirety of the Constitution and the Bill of Rights applies to everyone who is on U.S. soil, whether they are a citizen or not. They just do. You don't get to arrest an undocumented immigrant and then convict them and send them to prison without a trial, without a jury trial, without defense counsel, without being able to confront their witnesses. Constitutional rights apply to undocumented immigrants if they're on U.S. soil. Imposes limits on search and seizure powers in order to prevent arbitrary and oppressive interference by enforcement officials with the privacy and personal security of individuals. Whether a police officer accosts an individual and restrains his freedom to walk away, he has seized that person, and the Fourth Amendment requires that seizure to be reasonable. As relevant here, officers may stop an individual only if they are aware of specific, articulable facts together with rational inferences from those facts that reasonably warrant suspicion as to that individual. That individual may be in the country illegally. This requires more than inchoate and unparticularized suspicion or hunch of criminal activity. This is from the U.S. Supreme Court. It's U.S. Supreme Court case precedent. They can't do this. It's illegal. It's unconstitutional. And the majority conservatives are like, that's fine. We're going to let them do this, and we're not even going to offer you an explanation. Critically, a set of facts cannot constitute reasonable suspicion if it describes a very large category of presumably innocent people, like the 60 million Hispanic and Latino people living in the United States, roughly 50 million of whom are United States citizens. and who obviously are not here illegally. In Brigoni-Ponce, it's a case. For example, the court held that Mexican ancestry alone did not constitute reasonable suspicion to support stops by Border Patrol agents even near the border, because large numbers of native-born and naturalized citizens have the physical characteristics identified with Mexican ancestry. So too, in Brown v. Texas, U.S. Supreme Court case, the court held that standing in an alley in a neighborhood frequented by drug users did not rise to reasonable suspicion that because that activity was no different than the activity of other pedestrians in the neighborhood. And then a case, Kansas v. Glover, reiterated the need for an individualized suspicion that a particular person was engaged in a particular crime. You can't round up groups based on a hunch. Beyond just a demographic profile, the Fourth Amendment thus prohibits exactly what the government is attempting to do here: seize individuals based solely on a set of facts that describes a very large category of presumably innocent people. The factors also in no way reflect the kind of individualized inquiry the Fourth Amendment demands. This demand for specificity is the central teaching of this court's Fourth Amendment jurisprudence. Allowing the seizure of any Latino-speaking Spanish person at a car wash in Los Angeles tramples on the constitutional requirement that officers must have particularized and objective basis for suspecting the particular person stopped of criminal activity. The government, joined by Justice Kavanaugh, brushes aside this court's precedent with an appeal to probability, arguing that the high prevalence of undocumented immigrants in Los Angeles should enable agents to stop a relatively broad range of individuals. Without even a citation, the government asserts that 10% of the population of Los Angeles is unlawfully present. So it is inevitable and unremarkable that immigration officers would target any Latino person or any person speaking accented English or any person standing in a particular type of location or any person working a low-wage job in greater Los Angeles. So let's say that there are 100 undocumented immigrants, or there are 100 Hispanic and Latino people in Los Angeles. The government concedes that 90 of them are here legally. Only 10 of them are here illegally. The government is making the argument that they should be able to round up all 100 of them, including the 90 who are here legally and for whom they cannot articulate a particular set of circumstances for each one of them as to reasonable suspicion that that person has committed a crime or is in the United States illegally. That is unquestionably illegal and unconstitutional, and this court doesn't give a fuck. They're overturning the Fourth and 14th Amendments with one paragraph as to every Hispanic and Latino person in the United States. There are 60 million of them. Roughly 50 million of them are citizens. They are here legally. That's the current state of the United States Supreme Court. The government has provided no evidence showing that its seizures were based on credible intelligence about particular individuals at a particular location. Indeed, the government submitted no evidence about what facts its agents relied upon to conduct most of the seizures documented in the record. Rather, the government's own declarations suggest that the government generally targeted locations based on types of businesses that, in the agent's generalized experiences, undocumented immigrants supposedly frequent. That is plainly insufficient to give rise to a particularized and objective basis for suspecting a particular person under the Fourth Amendment. And it goes on from there, but I'm going to get to the conclusion here. Justice Kavanaugh's concurrence relegates the interests of U.S. citizens and individuals with legal status to a single sentence. positing that the government will free those individuals as soon as they show they are legally in the United States. That blinks reality. Two plaintiffs in this very case tried to explain that they are U.S. citizens. One of them was pushed against a fence with his arms twisted behind his back. The other was taken away from his job to a warehouse for further questioning. More fundamentally, it is the government's burden to prove that it has reasonable suspicion to stop someone. The concurrence, Kavanaugh, improperly shifts that burden onto an entire class of citizens to carry enough documentation to prove that they deserve to walk freely, every Hispanic and Latino person in the United States. The Constitution does not permit the creation of such second-class citizenship status. Boom, that's it. The equities therefore lie with plaintiffs. Countless people in Los Angeles area have been grabbed, thrown to the ground, and handcuffed simply because of their looks, their accents, and the fact that they make a living by doing manual labor. Today, the court needlessly subjects countless more to these exact same indignities. The court's order is troubling for another reason. It is entirely unexplained. It's one paragraph. In the last 8 months, this court's appetite to circumvent the ordinary appellate process and weigh in on important issues has grown exponentially on the shadow docket. Its interest in explaining itself, unfortunately, has not. There may be some good justification for issuing an unreasoned order in some circumstances, yet some situations simply cry out for an explanation, such as when the government's conduct flagrantly violates the law, or when lower courts and litigants need guidance about the issues on which they should focus. Here, for instance, the government will soon convene a hearing on plaintiffs' motions for a preliminary injunction and class certification with the benefit of a more fulsome record on which to evaluate the plaintiff's claims. When it does so, it will have only a concurrence and a dissent from which to reason. Neither the district court, nor meaning no oral argument, no record, no in-depth researched opinion that's 100 pages long. Neither the district court nor the parties will know whether the majority deciding this case believed the key issue was standing, the merits, or the scope of relief, or any one of which could have been the basis for the majority's order. Similarly, for each of those complex issues, it will be anyone's guess whether the majority thought there were evidentiary deficiencies, legal errors, or a combination of both. This situation demands more. The Fourth Amendment protects every individual's constitutional rights to be free from arbitrary interference by law officers. After today, that may no longer be true for those who happen to look a certain way, speak a certain way, and appear to work a certain type of a legitimate job that pays very little. Because this is unconscionably irreconcilable with our nation's constitutional guarantees, I dissent. I love Justice Sotomayor's dissents. She just ripped Brett Kavanaugh a new asshole, and the other 5 conservatives on the court as well. This decision is unconscionable. It is unconscionable in every way, shape, and form. It is disgusting, and it is further evidence that this Supreme Court is a rubber stamp for Donald Trump. It has become a partisan extension of the executive branch. It is no longer an independent institution. It has torched its reputation down to the fucking timbers, man. This court is no longer deserving of respect of Americans. This court is no longer deserving of the respect of American citizens.